So we continue the discussion on Novus ACTUS intervenis in this second part of the topic. Once again, I enjoin us to like the video and share, and also to subscribe so that you get notified as we upload new presentations. In the first presentation, we have laid down general principles regarding the determination of whether a course of events constitutes Novus ACTUS intervenis or whether it constitutes a continuation of the liability of the defendant that is before the court in the actual case scenario. In this presentation, we want to consider whether the act of a third party can constitute Novus ACTUS intervenis and circumstances in which the act of a plaintiff could also constitute a Novus ACTUS intervenis. So in this regard, we'll be looking at the case scenarios. Now, by way of recall, we remember that we have looked at the act of God or natural acts that could occur, and we have said that generally this act would break the chain of causation except there is evidence on the facts of each case, of the case before the court, that breach of duty by the defendant has contributed to the occurrence of natural event or has made the claimant more susceptible to injury by the natural event. Now, in this presentation, therefore, we look at the act of third party. When does the act of a third party constitute a break in chain of causation, constitute a Novus ACTUS, a new intervening act, which will not make the defendant to remain continually liable? In the example that we have been using, we talked about a situation where Mr. A has run into Mr. B and has caused an injury to the leg of Mr. B. Mr. B has a stiff leg, for instance, and because of that stiff leg, then he goes ahead to play football, and he has a fracture on the same leg. And Mr. Defendant tries to argue and say, because of the fracture was not the regular injury, it was actually the new intervening act of playing football. So these are some of the considerations. So, but in this regard, let's look at where we talk about act of third party. This act of third party can be an instinctive event, for instance, an involuntary act in the heat of the moment, and such acts would ordinarily not break the chain of causation. Scott and Shepard illustrate this perfectly as we have discussed in earlier videos. Then you have to talk about negligent acts of a third party. Can the negligent act of a third party constitute a Novus ACTUS intervenis? Can it break the chain of causation? This is premised essentially on facts of each case. We said earlier that this area of law is fact-dependent, it's fact-based. And so it's difficult to give a general principle that as regards the implication of a negligent act of a third party. Let's take the case of the Oropesa, where there was a collision between two ships, the Oropesa and the Manchester Regiment. Both were actually negligent. And the master of the Oropesa sent some of his crew in a live boat to go across to the Manchester Regiment and discuss possibilities of salvaging his boat. In the course of that journey, the boat capsized and some of the men died. And the action by the family raised the question whether the instruction of the master that they should go ahead in that boat and rescue was a Novus ACTUS intervenis, and that, it has nothing to do with the initial negligence of the defendant. And the court held that this is an action that flowed naturally, logically, foreseeably from the initial breach of duty by the defendant, and therefore it was not a Novus ACTUS intervenis, because it's an event that is a natural occurrence. In our conceptualization of Novus ACTUS intervenis, we had already said that it must be a new event, completely extraneous, unforeseeable, not flowing naturally, not in natural sequence, natural flow from the breach of duty that the defendant is being accused or is being alleged to have done. Now, so in this Oropesa case, the court said that to break the chain of causation, it must be shown that there is something which you can call extraneous, unwarrantable, a new cause which disturbs the sequence of events, something which can be described as either unreasonable or extraneous or extrinsic. That, for instance, in the Oropesa case itself, that it was not unwarrantable to attempt a rescue and to send those men to the liability. So these are some of the considerations that help the court. So case applications of these are many. In some cases where you have a defendant who has caused, for instance, a road traffic accident by negligent driving, the courts have held that where a subsequent driver, even if the subsequent driver is driving negligently, runs into that kind of obstruction that the first accident has caused and causes injury to the plaintiff, that the acts of the second driver is not a novus actus intervenis, that it is reasonably foreseeable that if you cause an accident, or another driver may also come, even if he's driving negligently, and run into that obstruction that your accident has caused. And so you cannot escape liability and claim that this is a new intervening act. So in that case, the court held that both were liable, the first driver and second driver. So it became a case of contributory negligence, and premised on the fact that these causes are cumulative causes. The first accident, which caused a state of affairs, the second accident by the second driver is, are cumulative causes, and the courts apportioned responsibility accordingly. You also see and compare the case of Knightley and Jones, where the court said that despite the fact that the defendant, that case was one that caused an accident in a tunnel, and the police were trying to attempt a rescue. And because of attempting a rescue, so many things went wrong decisions, unreasonable decisions, and then eventually the inspector instructed one of his men to drive against the flow of traffic in a motorcycle and try to close the tunnel against oncoming vehicles. And the court said that instruction that he should drive against oncoming vehicles, even though given in the course of a rescue operation, constituted a new intervening act that broke the chain of causation. Then you have considerations about reckless acts, that's where an act is actually reckless, it can break the chain of causation. In the case of Wright and Lord, for instance, you see that illustration where the plaintiff's car broke down while she was driving on a dimly lit road on a foggy night. Visibility was poor and her vehicle broke down. And the defendant driving his lorry very recklessly at an unreasonable speed in the light of the facts of the state of the road, ran into that vehicle that had already broken down, somersaulted onto the oncoming lane, and caused injuries to people on the other side of the road, and even the death of some other people. And the argument that by the plaintiff who caused the initial breakdown, that this act of the defendant, second defendant, this act that of driving recklessly and running into a broken down vehicle was a novus actus intervenis, which broke the chain of causation, was accepted by the court that yes, that it was completely reckless, and therefore that is actually the cause of this eventual death and injury to the plaintiffs. And so you see that when we say they talk about case specific actions, you can see the difference in the rulings, because in this context, in light of circumstances, it was completely a reckless act on the part of the subsequent tortfeasors. Case application of these scenarios that we are talking about is also found regarding medical negligence, medical, in treatment, whether if initially a defendant had caused personal injury to a plaintiff, and the plaintiff goes ahead to seek medical treatment, and then the treatment proves to be negligently administered, can we say that negligence in administering treatment is a novus actus intervenis that breaks the chain of causation? Or can we say that it is a reasonably foreseeable consequence of injury to a person that they will seek medical treatment? And if they seek medical treatment, that is then every process that follows is still to be ascribed to the defendant tortfeasors. The courts have held that general negligence will not, on the part of the medical team, will not break the chain of causation. And for a medical treatment to break the chain of causation between the initial breach of duty by the defendant and its injury to the plaintiff, it must be seen as something that is completely inappropriate form of treatment. A treatment that is grossly negligent and completely inappropriate as a response to the injury that has been brought before the court. So you have those line of cases there, whereby Barclays Bank, Prendergast against San and D Limited, where the court said that a wrong prescription by a pharmacist did not break the chain of causation, but rather it's contributory negligence, and the apportion damages 75% to 25% between the first and second tortfeasors. And then you have Raman and Area Rose Limited, where medical treatment was treated as a sole cause of the injury, and therefore considered a breach, a break in the chain of causation. Then you have rights at HI against Cambridge Medical Group Limited, where successive medical negligent acts were held not to be Novus ACTUS at interveniens where regards to medical negligence, unless it was gross, or unless it is egregious, the medical treatment would not ordinarily break the chain of causation. Then, in willful act of a third party, it's another thing that state of event that courts have had to consider, where a third party deliberately does something intentionally, willfully, does something, will break the chain of causation. Normally, the courts are reluctant to hold a defendant that is before the court liable for the acts of third parties, which he has no control over. So they would ordinarily hold that, and it is highly probable that such acts of third parties will break the chain of causation, would be regarded as a new intervening act, and that you should not make a defendant liable for these acts. However, the case or facts of cases actually determine eventually situations. And from the facts of the cases, the courts have had to hold that sometimes where the essence of your duty of care was to avoid these kind of third-party interventions, you will not be able to escape liability. In Lamb and Camden LBC, for instance, where the plaintiff's house was invaded by spotters, that is an intentional act of wrongdoing by a third party, because she had vacated the property and left it open because of the thought of the council, which had caused some damages to water pipes and had flooded her property. That damage to the water pipes, which was not repaired on time, and it made her to move out of property, left her exposed to being invaded by spotters. And the court held that the council cannot be held liable for the intentional wrongdoing of spotters. If you compare it with Ward and Cannock Chase District Council, in this Ward case, the court held that the act of the spotters was a foreseeable consequence of leaving a property unoccupied. But when you look at the facts of those two cases, you see some differences, in the sense that, for instance, in the case of Lamb, the location in Hampstead, London, was not likely to attract spotters, as against Ward and Cannock Chase District Council, where the location of the property will add a high concentration and a high probability of attracting spotters. So fact specificity is very critical in being able to determine the issue of causation and liability. You also have Stansby and Trauma, where the court said that, well, it's an act of intentional wrongdoing of a third party, but that wrongdoing was the essence of the duty of care that the defendant had, the duty to lock the door. When he left the door open and thieves broke in, that is the whole essence of the duty of care. So he cannot complain and say it was the act of a third party, and therefore it is a Novus ACTUS intervenis. That was not acceptable to the court. The act of a plaintiff may be an intervening act, like we said. And this act of a plaintiff can be negligent, or it may be willful, it may be willful, it may be intentional. Where it is a willful conduct of a claimant, the court usually look at questions of unreasonableness. How unreasonable is the act of the plaintiff? And the court may have to decide between saying it is a Novus ACTUS intervenis or it is a contributory negligence situation. You look at Reeves and Metropolitan Police Commissioner, where someone that was prone to suicide was in the custody of the police and is committed suicide. That was an intentional wrongdoing by the plaintiff. And the court said that, look, you cannot renege liability because it was an intentional act of the plaintiff, but they apportioned the damages on basis of contributory negligence. You also have mange and jury. There the plaintiff was injured and taken to the hospital, and he discharged himself against medical advice. Eventually, his leg was infected and had to be amputated. And the defendant argued that it was not their breach of duty of causing injury that caused the damage, but it was the act of defending of discharging himself from the hospital. But the court held and said that so when you are looking at the act of a plaintiff in such context, look at how reasonable is the act. So the court said that while the injury was foreseeable, it was unforeseeable that they have left the hospital against medical advice, and therefore the plaintiff and the defendant could not be exclusively liable. You also have Ekpo and Ineshuku, where the plaintiff was also injured in an accident caused by the defendant, and he refused to go for medical treatment in an hospital, but rather went to consult a local herbalist. And the leg became gangrenous and was amputated. When the facts came before the court, the argument, of course, again was that, look, it was not the initial injury that caused it to be amputated, because if he had gone to the hospital, he would have treated properly and would not have lost his leg. And so it was the act of discharging himself that constituted a Novus ACTUS interveniens. But the court held in that case that is the act of not going to the hospital or visiting a native doctor was not unreasonable in the light of Nigerian society, where many believed in their native doctors. Remember, that was the case in 1954. And so the court said that there was nothing unreasonable in going to visit a native doctor. And so you take him as your victim as you find him in that context. You have Matthew and Holland and Anen and Kubitz Limited, where the defendant had caused personal injury to the leg again of the plaintiff. And as a result of that personal injury, his leg sometimes gave way when he walks. Unexpectedly, the leg would collapse under him. And this plaintiff was descending a set of staircase, was with his wife and his brother-in-law and his son, a young son, and he was descending a staircase which had no railings. And as he was descending, his leg gave way. So he jumped forward and landed on the railing so that he can prevent himself lying, having further injuries. So he jumped when his leg gave way, and he sustained further fracture to the leg. And the defendants argued and said, look, their initial injury, their initial wrong to a breach of duty was not because of this fracture. It was the unreasonable act of the plaintiff descending the staircase. He could have descended the staircase with the help of others, and then the additional damage to him was the question before the court. And the House of Law held that the jumping by the defendant, by the plaintiff, was not unreasonable, but he had placed himself in a situation that was likely to imperil him, that it was unreasonable for him, knowing his state of health, to descend a staircase that had no railings without the help of others. His wife could have helped him, his brother-in-law were there, they could have helped him. So his act was unreasonable. So for the further fracture that he sustained as a result of that event, the defendants could not be liable. In Wayland and Cyril Lord Carpet Limited, also the defendant was injured and had to wear a collar as a result of the breach of duty by the defendant. That wearing of the collar prevented her from wearing her bifocal lenses regularly. And she was descending the staircase of her son's office, but she could not even see well. She had to go to the son's office to ask for assistance to drive her home. And as they were descending the staircase, she fell down the stairs and sustained further injuries. This was the further injuries that was brought before the court. And the court held that there was nothing unreasonable in what she had done, and therefore there was no Novus ACTUS interveniens. And so in Spencer and Wincanton Holdings Limited, there was an initial leg amputation due to the negligence of the defendant. Then the plaintiff was riding his vehicle, and he was not supposed to go without his prosthesis. He got to a filling station, got down without his prosthesis, leaned on the vehicle and tried to dispense fuel into his car. And he fell, and instead of being on, he now became confined to a wheelchair because of the further injuries now sustained. And they argued that the act of the plaintiff was, the cause of the injury was the new intervening act, that it was unreasonable for him to do so. And the and the court held that the act of the plaintiff was not a novus actus intervenis. It was not unreasonable in the light of circumstances of the case, because he has to go on with his life, and so what he did was not unreasonable. So most of the times, the court looks at the act of the plaintiff, whether it is reasonable in the context. You have the case of Clay and TUI UK Limited, where we said that I am the LJ, I can minimize basic principles. I said that if it's reasonably foreseeable that something will happen as a result of your breach of duty, then that act that is foreseeable cannot be a novus actus intervenis. But where the act is unreasonable, it's likely to be a novus actus intervenis. In this case, the defendant was trapped with his family on the balcony of a hotel building, and he decided to climb over the balcony onto the adjacent building. When he stood on the ledge gave way, and he fell about 30 feet down and sustained injury. And the question was, the law that got locked up was represented the breach of duty. And the question was whether the breach of duty by the hotel and the injury that sustained, whether there was an intervening act, that is, his act of climbing over the balcony to try and get to the next building, was it an unreasonable act that can break the chain of causation. And because of the Court of Appeal held that the legal cause of the injury was was not the defective lock, but the unreasonable act of the claimant in attempting a highly dangerous escape from a mere inconvenience. That, in other words, it was just a mere inconvenience. Could have waited for someone to rescue them, for them to be discovered. They were not imperiled in any way. So his attempt to escape from that building was not a reasonable response to a mere inconvenience. And the real cause of the legal injury, the real cause was not the defective lock in the door, but the act of escaping, of trying to escape in a dangerous manner. And therefore, it was a break in the chain of causation. And when you look at that case, for instance, where I say it is fact specific, like I keep emphasizing, let us assume that he was trying to escape from a fire incident when they were locked in that place. It probably would have been reasonably foreseeable that he should climb. His action of climbing over and attempting a rescue would have been reasonable if there was a fire and he's trying to escape. But in that case, it was just an inconvenience that they could have been rescued from. So usually, when you are looking at these case scenarios, the court, you look at whether sometimes once it is positive act, it's likely to generate a novus actus intervenis as against omissions. Typically, omissions would not usually, in most cases, constitute a novus actus intervenis. If I stand by, for if A pushes B into the lagoon, and I stand by, and C stands by and watches B drowning, maybe in the pool or in anywhere that he has been pushed, or does not do anything, or A causes a fire, and the fire service, which has the statutory duty to attempt that kind of rescue, stand by in breach of even when it is a breach of their legal duty and they do not do anything, omission, it will not break the chain of causation. Usually, such omissions will not break the chain of causation. So, considerations as whether the act was done intentionally or deliberately matter, whether it is a voluntary act or it acts in the heat of the moment, whether it is based on informed decision and knowledge of the consequences of the action, and whether it is reasonable. So, like I said earlier, the omissions will not ordinarily break the chain of causation. But sometimes when the omission represents a failure on the part of a plaintiff to mitigate the loss, the law expects, yes, somebody has caused the injury, but you should mitigate your loss. You should stop your loss. You don't just sit back and say, okay, I will not do anything so that the loss can be greater. If you are injured, the law expects that you go to the hospital. If you have a damage to your property, the law expects that you do something to protect it from further damage. So generally, it is recognized that a plaintiff has a duty to mitigate the loss. So omission to do so would not be tied to the act of omission initial defendant. However, there are some set of cases where the courts have held, for instance, that failure to take treatment, like Jehovah's Witnesses that say, oh, I will not take blood transfusion because it's against my faith, that it will not break the chain of causation. Or a person who was attempting sterilization does not want to get pregnant again. And then, because of the negligence of the doctor in doing the sterilization, the person gets pregnant, and you say, oh, the person should have aborted the pregnancy or should have given up the child for adoption. In such cases, the courts in English jurisprudence would not take it as a break in the chain of causation. Such acts are not regarded as unreasonable acts of a plaintiff. And in such jurisprudence, which Nigerian courts follow, they are not treated as a break in the chain of causation. Case applications also continues by looking at situations where somebody commits suicide. So you cause injury to A after some years decides to commit suicide because maybe they became depressed, maybe the person become bedridden because of the initial personal injury that you have caused, or maybe their body, maybe they got burnt because of your carelessness in causing a fire, and they are deformed physically, and they become depressed, and the person now commits suicide. In such cases, the question arises whether the suicide has broken the chain of causation, whether it's an intentional wrongdoing of the plaintiff, which cannot be ascribed to the defendant. And the English decisions have held that such suicides, where they arise from depression caused by the initial injury by the defendant, do not break the chain of causation. And so the fact that the suicide was unforeseeable is immaterial. So it shows that sometimes even unforeseeable acts will not ordinarily or automatically break the chain of causation. We said earlier in the principles in TUI case that where the act is unforeseeable, it is highly probable that it will break the chain of causation. But it is not an absolute, as you can see. In core and high BC vehicles repeated suicide by the victims, the court held that the defendant was still liable because the suicide is not even from a mind that is informed. It was not an informed decision. It was not a voluntary decision. It emanated from someone who has mental incapacity, so to say, and therefore it cannot break the chain of causation. And you also have Reasonableness, Metropolitan Police Commissioner that we talked about earlier, picketing against Pointers Transport Services Limited, where the court said that the immediate cause of the death is that the person hanged himself as a result of acute depression. And while depression was not reasonably foreseeable by the defendants who had injured him, it was directly traceable to the physical injury that he had initially suffered. So defendants in cases like this are unable to hold that there is a breach in the chain of causation. And so therefore, not all unreasonable conduct will break the chain of causation. We have emphasized the fact that where the act is unreasonable, it will break the chain. There's high probability that it will break the chain of causation. But in Spencer and Wincanton Holding Limited, the court said that the line between a set of facts which result in a finding of contributory negligence and a set of facts which result in a finding that the unreasonable conduct of the claimant constitutes a novus actus intervenis is not, in my view, capable of precise definition. You cannot actually give it a precise principle of law. Sometimes unreasonable conduct can be held to constitute novus actus intervenis. Sometimes it can be held to constitute contributory negligence. Then you can see other case application. When the conduct is reasonable, it is most unlikely to break the chain of causation. Still talking about this case application of reasonableness and unreasonableness. AMA and Kensington and Chelsea and Westminster authorities clearly relevant in this case. The defendant was supposed to perform a sterilization procedure on the plaintiff so that she will not get pregnant and avoid the risk of having congenitally abnormal child. After the supposed sterilization, she discovered she was pregnant in the second trimester, and she declined to have an abortion. And the defendants argued that the refusal to have an abortion was an unreasonable refusal, and therefore broke the chain of causation. And the Court of Appeal held that it is not unreasonable for a woman to decline an abortion. save in the most exceptional circumstances. So the failure to have an abortion does not break the chain of causation. You also have McFarlane and Tayside Health Authority, where the woman also, who had not been successfully sterilized, refused to abort the child or to give up the child for adoption. And the defendants tried to argue and say, look, that refusal was a Novus actus intervenis, and they should not be liable for the cost of bringing up this healthy child that she has had. And the court refused, the House of Lords actually, on issues of policy, they were not ready to consider the birth of a healthy child as a damage and to give cost for rearing a healthy child, in a wrongful birth case. So this shows us some of the policy issues that will come into play, that it cannot be conceived of as a wrongful birth case where you have had a healthy child to now sue for the cost of bringing up that healthy child. That does not exclude the possibility of getting damages, a head of damages for pain and suffering in such context. You also have the case of Rees and Darlington Hospital NHS Trust, where the court held that the birth of an unexpected child cannot be solely a financial liability. When some people are looking to have a child, they are trying everything to have a child. To now construe the birth of a healthy child as a financial liability would not be proper in law. The approaches to these various across jurisdictions, if I may mention, look at the American jurisdiction, Canadian, Australia, while the particular jurisdiction determines the kind of approach that the court would use, but we are focusing on the cases in English jurisprudence. The summary of our discussion on Novus Actus Intervenis is simply that Novus Actus Intervenis traverses the line between causation in fact, remoteness of damage, defenses of contributing negligence, and preventing non-fit injury. You would see that some of the facts that we have presented, you could also use them for issues of causation in fact, consecutive causes, and what have you. When you have determined that the but-for test and you have held that, yes, factually, the defendant is the cause of the injury, you also have to determine that legally, is it the cause of the injury? In the course of determining legal causation, some of the principles that we have talked about, remoteness of damage, we have talked about Novus Actus Intervenis, and we will be looking at contributing negligence as a defense, which I have mentioned copiously in the course of the presentation. The court tries and look at the adoption of Novus Actus Intervenis, which means a new intervening cause. Where it is found that there's a new intervening cause, the law says that you cannot continue to hold this defendant liable. And the new intervening cause is the sole cause and the true cause of the damage involved. In given facts, it is expected that as you look at the nature of the act to determine the principle to apply, is it an act of God? Is it an act of a third party? Is it an act of the plaintiff? That helps us to conceptualize the relevant principles. In given facts also, you determine whether this act of the defendant or of act of a third party or act of a plaintiff is a negligent act or a reckless act or a willful act. And from the discussion, you would have noticed that the principles vary. In rare cases, act of God, when the act of God arises, it's usually highly possible that it breaks the chain of causation, except there can be found evidence that the defendant's conduct materially contributed to the plaintiff's injury. When it comes to negligent acts of third party, you cannot formulate general principles. It's a bit difficult. And the court will look at the facts of each case to determine whether there is a Novus Actus Intervenis. Okay, and we have looked at some of these cases where the court have said in some, they have a Novus Actus Intervenis. Sometimes they will say it is joint liability between the defendant and the third party, or between the defendant and the plaintiff. Reckless or grossly negligent conduct of a third party may be a Novus Actus Intervenis. It can be in a third-party medical treatment, for instance, can be reckless driving. This can be acts of that break the chain of causation. Generally, willful acts of third parties constitute Novus Actus Intervenis. Note that I said generally. Sometimes, if the court can find that the essence of your duty of care as a defendant is to prevent that willful act of a third party from taking place, then that will not be a breach. That will not constitute a breach, a break in a chain of causation. It will not constitute a novus actus intervenis. Generally, also, negligent acts of a plaintiff would constitute novus actus intervenis where it's unreasonable, so unreasonable as to obliterate the defendant's breach of duty as exemplified in play against TUI that we talked about earlier. We should also note that not all unreasonable acts of a plaintiff are novus actus intervenis. Not all unreasonable acts of a plaintiff can break the chain of causation. Sometimes when the act is unreasonable, the court will say the plaintiff is contributory negligent. And the courts are actually more disposed to holding that the act of a plaintiff is contributory negligent. Oh, he went to go and play football with a fracture, with a stiff leg. Oh, let's apportion the negligence between the plaintiff and defendant. So defendant is 65% liable, the plaintiff is 45% liable. The court is more disposed to say, because the defense of contributory negligence makes you apportion the liability and it still gets some damages paid. But when it comes to novus actus intervenis, you are completely eroding liability in the defendant and the plaintiff may not get anything. So in the example of the fractured leg, then you might say the defendant is going to escape liability absolutely. Courts are more disposed to hold that a plaintiff's act constitutes contributory negligence than to hold that it constitutes novus actus intervenis. So we also should note the significance of an act that is positive. When the act is positive, as against an omission, it is likely to be a novus actus intervenis. When it is deliberate, when it is informed, based, for instance, acts of mentally deranged people may not necessarily, highly unlikely to constitute a novus actus intervenis. Acts of children, highly unlikely to constitute a novus actus intervenis. Voluntary acts, as against involuntary acts, they are unreasonable acts as against reasonable acts. These are some of the principles that the courts have used to determine the question of whether a set of facts constitutes novus actus intervenis or not. Don't forget what it always said, that when you look at some of these heads of principles, doctrines, and what have you, you might not be able to clearly move them away from other principles that you have discussed earlier. A lot of these principles are placed in different compartments in various texts by authors or by courts. Sometimes they are placed under duty of care. Sometimes they are placed under factual causation. Sometimes they are placed under remoteness of damage. But whichever process it is taken, it's just a reflection of the historical development of the law. All of them represent gatekeeping by courts, gatekeeping by law to reduce the scope of liability. To say, look, we must draw a line somewhere and we cannot continue to hold a defendant liable ad infinitum. The law must be able to draw a line and say, this is when your liability starts and this is where your liability ends. Whatever follows subsequently is an independent event for which you should not be liable, so that we do not therefore get muddled up by saying, oh, but this set of facts would also constitute a case scenario under breach of duty or under like duty of care in the first place. So this has been therefore an exposition on the doctrine of novus actus intervenis. And it is the concluding video, like I told you at the beginning. We have done the first presentation where we looked at the basic principles of how the court looked at the meaning of novus actus intervenis as a new intervening cause which breaks the chain of causation, and what principles of law be applicable. Please don't forget to like, share, and subscribe to this video.